Courts need experts, but who decides the law? In the previous video, I asked whether judges should be allowed to consider legal solutions developed in other legal systems. That leads to another important question: who should evaluate those solutions? Modern courts increasingly depend on specialists, psychologists, doctors, social workers, technical experts, and particularly in family proceedings, their knowledge can be extremely important. But there is a distinction we should not forget. Expertise about the facts is not the same as expertise about the law. A psychologist can help a court understand psychological circumstances. A doctor can provide medical findings. A social worker can explain social or family circumstances. But questions concerning fundamental rights, proportionality, statutory interpretation, procedural fairness, and ultimately the legal consequences of those facts remain legal questions. I became particularly conscious of this distinction through my own experience with family court proceedings, which I also discuss in my book. Legal ties, family bonds. There can be proceedings in which several non-jurists contribute professional opinions to the court. There is nothing inherently wrong with that. The problem begins if their professional expertise starts to substitute for legal reasoning rather than informing it. And this becomes especially important when we introduce comparative law. A foreign judgment should not determine the domestic case. An AI system should not determine it either. They can provide knowledge. But whether a foreign legal principle is compatible with domestic legislation, constitutional rights, and the structure of the domestic legal system must ultimately be evaluated through qualified legal reasoning. That is the distinction I want to preserve. Experts help the court understand the problem. Jurists must determine its legal meaning. I developed this argument in much greater detail in my article Comparative Law as a Source of Legal Development on law-clinic.au.